Mr. Davies died, his wife did not. Despite the fact that I was accused of planning the robbery, but not of killing someone, trying to kill someone, arranging a killing, or even knowing that someone would be killed, under the laws of the state of California, I was still death qualified. I hired a really great lawyer, and I spent the next 4.5 months in custody, and after 4.5 months, the case against me was thrown out because there was no evidence against me. One of the unfortunate results of the 4.5 months I had been that I was now totally broke. I had spent every dime I had, borrowed every dime I could get my hands on, and done every single thing that I could in order to get these ridiculous charges against me dismissed. And they were. But one of the perpetrators went to trial. He was the first one to go to trial. His name was Gary Massey, and he never said a single word during his trial. Accused nobody, stated that he had been involved, but that it was a minor involvement as far as he was concerned. He was convicted and he was sentenced to life without the possibility of parole. The same day that he was convicted, he went back to the jail, picked up the telephone, called the district attorney, and said, "I can help you." They took him back to court, and they recalled his sentence, which left him legally unsentenced for 3.5 years. They also rewarded him in many, many other ways in order to ensure his continuous cooperation with the prosecution. They worked with him, they spent a lot of time with him, and they helped him to come up with the statements that he came up with. Based on his statement, they rearrested me. And frighteningly enough, even knowing the basis for the rearrest and how this statement against me had been cobbled together, I was once again charged with the death penalty. I was still death qualified under the laws of the state of California. This time I spent 8.5 months in custody. I was completely out of money, so I had to have the court appointed an attorney for me, and he was basically just good enough to get me convicted. He never had a case like mine. He didn't have the background. His father was a very successful criminal attorney, and the one thing I can tell you for sure, it's not hereditary. It's not and I was on my way down to disaster very quickly. Fortunately for me, at this time, the California Supreme Court issued a decision in People v. Carlos in which they decided that if you do not kill someone, try to kill someone, have knowledge in advance of killing someone, that you could not be executed yourself. And so the next 2 days later, the court released me on a $25,000 bail. Unfortunately for my fellow citizens in California, People v. Carlos lasted exactly 8 years. The court reversed that decision in People v. Williams, and it is now entirely possible to be executed in the state of California, even if you didn't kill someone, try to kill someone, know someone was going to be killed, or have any involvement with the homicide itself. It can be a homicide of which you were totally unaware, but nevertheless, you yourself can be executed, and you are death qualified under the laws of the state of California. At my trial, probably the most compelling thing against me was the district attorney's own statements. The district attorney stated in court, "This witness has no reason to lie. He just wants to clear his conscience. There's no reason at all for him to be lying. We have promised him nothing." The district attorney had already signed a deal, which he put in another file, in another court, in another case, stating that once Mr. Massey went to be resentenced, the state would not oppose a Williams motion, and therefore he would be resentenced to 25 years to life. The district attorney suppressed a great deal of evidence that was exculpatory, that tended to prove that I had not committed the crime that someone else had. And most of the information that I share with you, I had no access to and I had no knowledge of for many years, unfortunately. At the trial, after the district attorney said this, the other thing that he continued to do was to make certain statements that are actually illegal and unconstitutional. Nevertheless, even though the judge called him up and said, "I think you're getting a little close to the edge here," the statements were not disqualified, and he was allowed to basically do as he chose to do in the courtroom. I was convicted, and at my sentencing, the district attorney stood up and said, well, Gloria Killian's never been in trouble before. In fact, she's been going to law school, and as far as we know, I don't think she even has a traffic ticket, so she should get more time than anybody. And I did, more time than the perpetrator himself. I was sentenced to 32 years to life in prison, and I was shipped off to the penitentiary. 90 days after after I was sent to prison, the witness against me, Gary Massey, wrote a letter in which he recanted his testimony, in which he said, I lied my ass off on the stand for you. Sorry, Reverend. Direct quote. I gave you Killian, what are you going to do for me? And they suppressed it. So within a year of my being convicted and sent to the penitentiary for the rest of my life, basically, my conviction should have been reversed, and I should have been out and at the very least getting a new trial. But they suppressed it. He recanted 3 more times over the years, and it wasn't for 10 years that this information came out, that I was able to acquire this evidence, and that finally it was able to start winning my battle to be free. It only took another 5.5 years. The state of California, the district attorney and the attorney general's office fought me every single step of the way. They actually took my case all the way to the United States Supreme Court. My conviction was reversed in March of 2002. And despite the fact that there was a lot of publicity, everybody knew, I only had one other problem: I couldn't get out of prison. The prosecution continued to insist, one, they were filing motions on everything they could think of, but mainly they continued to insist that I was a threat to society and that I should not be released from prison, even though I had no criminal conviction at all. It was a very unpleasant 4 months. Well, maybe I was just unpleasant for 4 months, but that's how long it took me to actually get out. They released me on a $250,000 bail, knowing that, obviously, that I had no money. I'd been in prison 17.5 years. And they put me on federal probation. Again, I have no criminal conviction at all. All of these things that they did, going to the en banc, the probation, the money, every single thing that was done in my case after my conviction was reversed was simply an attempt to punish me a little while longer. It's very clear that in this country we do not like to reverse convictions, and they will do whatever they can to continue to make you as miserable as possible, as if you deserve more punishment for not having committed a crime and for having been wrongfully convicted. They destroyed my life, but